Welcome back here to Live Now from Fox. Well, now an update on a story we have not touched on, like I said, in some time, the Bryan Kohberger case. For those unfamiliar, Kohberger is the man accused of stabbing four University of Idaho students in their off-campus house last November. The murders and subsequent manhunt captivated the nation, and now we have another update in the case. Joining us now with more legal analysis, legal expert Nicole DeBoard, and we want to talk about this, Nicole, even further. Good to see you. I know we brought you on to talk about this case specifically, but it looks like Kohberger's attorneys in the present moment, they're trying to make the surviving roommates from that off-campus house who found the bodies testify in court. Now, all throughout this story, we have not heard, or we do not know who those surviving two roommates are. What do you make of this push?
It sounds like the defense believes that the surviving roommate has information which tends to exculpate or indicate that perhaps Kohberger is not the correct suspect. And they want to call him to have the judge evaluate this testimony in consideration for how the case should move forward. I'm not sure there's any real legal way that she can prevent the defense from subpoenaing her and calling her as a witness. It may be that the court instead takes steps to protect what she has to say and her face during the testimony.
Okay, when you say exculpatory, though, and if the defense thinks that, no, it could be beneficial to Kohberger's case, it's got to be really good, doesn't it?
It has to tend to point to a not guilty type verdict, right?
Okay.
It has to be evidence that points to an additional suspect that hasn't been revealed, or information that would tend to show that Kohberger is not guilty of the crime for which he has been charged.
Okay, so when you talk about these roommates, there apparently is the second roommate. He or she is a Nevada resident, and there's this talk now about bringing these roommates in to testify. Like I said, does the defense, though, have the power to summon them, being that she is from a different state? Do they have the power to subpoena a witness who lives in another state where the crime did not occur?
They can do that. Now, what happens when you have to subpoena a witness who does not reside in the state where your case is being heard is you have to do something called perfecting the subpoena. And what that means in plain language is you have to go to a court in the jurisdiction where you're trying to get the witness to come from and have a judge in that jurisdiction take a look at the subpoena and indicate whether or not they too believe that the testimony is appropriate and that the subpoena has been lawfully issued.
Okay, but say those witnesses, potential witnesses, the roommates, the surviving roommates, say they refuse to comply with the subpoena. That could really delay things if there's this whole tangential side subpoena fight going on. Say they don't want to do it. They don't want to testify. Then you have that in the mix, right?
That's exactly right. If her lawyers go to bat, his or her lawyers go to bat to try to prevent the subpoena from being perfected, there will need to be a hearing in that matter to determine whether or not they can lawfully subpoena this witness. And that could take some time and delay the hearing. But once that subpoena has either been perfected or it has not, we'll know whether or not this witness will be forced to come and testify in this trial.
Okay, so when you talk about the grand jury testimony as well, we've heard the grand jury could be done behind closed doors. What impact would that have on the trial there in Idaho? Are these two things happening concurrently? You have the grand jury, it's meeting, it's calling witnesses, and then the trial, which will begin in June, of Kohberger himself?
These two things are happening on separate paths. So
Okay.
a grand jury, it simply determines whether or not there's enough information, legally speaking, to move forward with a felony charge of a particular type. And they can actually indict for additional charges, or can decide that different charges are appropriate than ultimately what the prosecutor recommends. Or they could decide that no charges at all are appropriate and issue what is called a no bill. Meanwhile, what the court is doing is handling pretrial motions, dealing with discovery complaints and objections and motions, and making sure that the case stays on course for one day, ultimately being brought to a conclusion in court. And that is different than what's happening in front of the grand jury.
So there's also this kind of interesting side narrative, side plot playing out as well with a police officer in Latah County in Moscow, in Idaho. The prosecutor's office mentioned disclosing, quote, potential Brady Giglio material related to a police officer involved in the massacre probe. What kind of material do you think is the prosecutor referring to? Are they trying to look at how the police responded that morning?
They could be looking at all kinds of things, including the reputation of a police officer who was responsible for some part of the investigation of the case. So Brady and Giglio are cases that in the United States Supreme Court give defense the right to have, again, that word, exculpatory evidence. So information which would tend to point away from the likelihood of guilt of the accused. And sometimes the credibility, for example, of an investigating officer can be crucial to the state's case. And if that officer has complaints against him or her in the department, it may be that the defense is entitled to learn about what those complaints were to determine whether or not that officer is reliable or credible.
Even if those complaints have nothing to do with the Moscow murders there in Idaho last November. It could just be something in his personnel file, past behavior, past alleged misconduct. They don't have to be related. Is that what you're saying?
They don't have to be related. It could be a finding, say, by the department that the officer in the past has not been thorough, or that the officer hasn't been honest or forthright, or has been found to have executed poor judgment in the handling of the case. And if that type of information exists, the prosecutor is duty bound to turn that over to the defense so that the defense can think about it and investigate it and potentially use it in the cross-examination, ultimately, of that police officer on the stand.
Okay, and just lastly, Nicole, you know, way back when a gag order was placed on this, there was a push by several media organizations to kind of lessen the gag order or lift it altogether. A lot of those motions have been denied. You know, is this customary to have a gag order on this case almost from the very get-go? Are we not going to be able to see some things until trial, do you think?
I think that that's absolutely the case. We will certainly have to wait until trial to see a great deal of the information here. It's not customary, but a judge has to be very careful when a case has gained quite a lot of attention, either in the media or just throughout the internet, to prevent external information that is not brought up in court from infecting the jury's decision in the case. And so while judges don't like to issue gag orders, sometimes they feel it's necessary to make sure that juries base their decision entirely on what's happening in court and nothing else.
And Nicole, just lastly, I know we're some weeks away from the trial beginning, but having watched this so closely, I think the run-up to the trial is so interesting because you can kind of divine almost how the trial will go. I'm not saying on whether or not a conviction will be guaranteed, but there are certain hiccups. Each side kind of has their victories and losses, the prosecutors and the defense, in the run-up to this. What does your gut tell you right now going into this trial?
Well, I think for exactly the reasons that you mentioned earlier, since we just don't know exactly what details we'll ultimately hear in that courtroom, it's impossible to say who's ahead. The state has a huge burden, and it is to prove beyond all reasonable doubt that the suspect they have charged is in fact guilty of the crime. And we will all be eagerly awaiting the days in court where we can hear and see what it is they think they have for evidence for ourselves.
All right, Nicole DeBord, as always, we appreciate your insight into these major legal headlines, and we'll talk again.
Thanks for having me.